Okay, let's get started. Welcome everyone to this year's recap of the case law of the planning case law of last year, 2023. It's hosted by Landmark Chambers. We're delighted to see so many of you joining us. This has become something of an annual tradition now. This year I'm joined by Rebecca Sage and my name is Matthew Fraser, and we're both specialists in planning and environmental law at Landmark Chambers. The purpose of the next 3/4 of an hour is to do a recap of the key planning cases of 2023, and also to touch on some other cases of note, and then attempt to look ahead at 2024 to some expected highlights. And hopefully there'll be something in this for all of you. For obvious reasons, we're not going to be doing any deep dives into any of the cases today, but hopefully it's enough to just give you an indication. I'm sure for many of you, these will be some familiar cases that you've heard about already. But it's amazing how quickly you can forget something that happened nearly 12 months ago. So we'll start with Rebecca, who's going to touch on two cases dealing with Section 73 and varying planning permissions. Over to you, Rebecca.
Thank you very much, Matt, and good morning, everyone. So yes, as Matt says, I'm going to start by talking about two cases on Section 73. As we all know, that governs applications for permission for development without compliance with conditions attached to a previous permission. And of course, it results in the grant of a new permission. Now, before I get into the two cases, just by way of reminder, the key case that we have at the moment is that of the Court of Appeal in Finney and Welsh Ministers, where it was held that Section 73 could not be used to achieve a variation in condition which would conflict with the operative part of the original permission, i.e. the description of development. Now, the two cases that I'm going to talk about have considered the scope of that restriction, the Finney restriction, and indeed whether it is the only restriction on the use of Section 73. So the first case, Armstrong, is up on the slides now. And funny Matt should say about things happening a year ago, because judgment was handed down in that case on the 27th of January last year, so almost bang on the Armstrong anniversary. Now, in that case, there was no conflict with the operative part of the permission, a la Finney, but the question was whether that was the only restriction on the use of Section 73. And the Secretary of State in Armstrong argued that it wasn't, and that Section 73 could not be used where there was a fundamental alteration of the original permission, even where there was no conflict. So, was there a further restriction? Now, before answering, it's worth considering the facts very briefly. And as you can tell from the text on the slide, it would have been lovely if I had had the slide space to put on a few pictures, but alas, you'll just have to imagine in this case. So permission was granted in 2007. The description of development was for construction of one dwelling. There were no conditions attached relating to plans or drawings. In a sequence of events which is probably quite familiar to all of you, Mr. Armstrong applied in 2020 under Section 96A to add a condition requiring development to be carried out in accordance with the plans lodged with that application back in 2007. And those plans, the original plans, showed a house which was described by the judge as of irregular shape and in modern architectural style. But a couple of months later, Mr. Armstrong showed his new preferences for this house, and he applied under Section 73 to substitute new drawings, which the LPA described as Alpine Lodge style. And it refused the application on the basis that the Alpine Lodge would differ materially from the approved permission. And Mr. Armstrong unsuccessfully appealed, and he then brought an application under Section 288, in which he represented himself. Pausing at this stage, just to note that at that time, the planning practice guidance said that one of the uses of Section 73 was for a minor material amendment, which was defined as not substantially different from the existing permission. And both the LPA and the inspector relied on that part of the PPG when making their decisions. And while the judge in Armstrong did find that that was ultimately misleading, it is worth recalling that the accuracy of the PPG wasn't really an issue in Armstrong, and the Secretary of State had conceded that the reference to minor material amendments didn't reflect the statute. So while some commentators have focused on this PPG element of the case, I'm actually not going to. I'm going to focus more on the one restriction or two question. And the judge answered that question by saying there was only one restriction on Section 73, and that is the Finney restriction. And he reached that conclusion for 8 reasons. Now, I don't have time to go into all those reasons, but it is worth noting that several of these were an exercise in statutory interpretation. And in particular, the judge pointed to the wording of Section 73, saying that giving the words their natural and ordinary meaning, there was no restriction relating to fundamental variations or non-material amendments. He also noted, when looking at the scheme established by the 1990 Act as a whole, that there was that Section 73 is limited to applications for non-compliance with a condition, and that is a restriction in itself. And the judge thought if Parliament had wanted to impose further limitations, it could have done so. And he pointed in that regard to Section 96A, which applies generally to planning permissions, but is limited in scope to non-material amendments. Significantly, the judge also reviewed the relevant case law, which included Finney as well as various other cases on Section 73. And he found that those cases lended no material support to the Secretary of State's argument for a further restriction. And when the decision came out, some pointed that that decision was perhaps surprising, particularly given the view expressed by Mr. Justice Sullivan in another key case, Arrowcroft, where he thought that new conditions must have been ones which could be imposed on the original permission in the sense that they don't amount to a fundamental variation to the original proposal. Now, Arrowcroft was a case where there was no conflict, as the judge noted in Armstrong, so those observations weren't part of the ratio of the case. However, the decision in Armstrong arguably did sit a little bit uncomfortably with that suggestion in Arrowcroft. Now, following Armstrong, lots of developers got quite excited about the broad scope of Section 73, although they may have been forgetting, of course, that the planning merits are still relevant, and the judge in Armstrong was clear about that. So from January to September, everyone was thinking that Section 73 was relatively broad, but then judgment came out in Fisk. There we go. And the question in that case concerned the scope of the Finney limitation, and in particular whether any inconsistency with the operative part of the permission were sufficient to engage that limitation. Now, I hope the parties in this case don't mind me saying that the facts are possibly less compelling than those in Armstrong. And the key parts are very briefly as follows. So the initial grant of planning permission was for a solar park, including a substation, and that permission was granted subject to conditions. Those conditions required the development to be carried out in accordance with approved plans, and those plans included a drawing of the type of substation, but it wasn't in fact shown on the site layout plan, and then provided for the full details of the substation to be submitted for approval. The developer then applied for another permission in 2021 for a substation compound within the original solar park site. And in 2022, the developer successfully applied for permission under Section 73, effectively to remove that original substation by omitting the substation condition from the original permission and references to the substation from the approved plans. And the developer said the reason for that was, in effect, because they'd already applied for separate permission in 2021 for a different substation. So the Section 73 application was needed to allow the permissions to operate in parallel. Now, the claimant in Fisk argued that that Section 73 permission was ultra vires. And two main thrusts of the claimant's argument in that case. The first was that there was a conflict, a Finney-style conflict, between the operative wording of the original permission and the condition to the Section 73 permission, because that effectively prevented the building of the substation, which was in fact part of the operative permission in the first permission. And then secondly, the claimant said, well, even if there was no conflict, the removal of the substation was a fundamental alteration of the original development. So again, we've got this fundamental alteration argument coming back. The local planning authority, in fact, argued that if there were a conflict, then it was only where that conflict was fundamental that Section 73 couldn't be used. Mr. Justice Morris in Fisk again looked at the authorities that had been considered in Armstrong as well, albeit in a different factual context. And he said, and it's quite reassuring in my view that he did say this, that the decided cases do not present an entirely clear picture and are not always easy to reconcile, which hopefully makes us all feel a bit better about trying to untangle the current state of Section 73. But in reality, in Fisk, the heart of the dispute was about a particular paragraph of Lord Justice Lewison's judgment in Finney and his analysis of 2 paragraphs of the decision in Arrowcroft, which I mentioned earlier. So it was quite a narrow point, but of course with wide implications. And the judge did have some sympathy in the local planning authority's position in Fisk based on the authorities, but ultimately he found for the claimant, and he found that there was, under Section 73, no power to introduce a condition which created any conflict or inconsistency with the operative wording. So there was no need for the change to the conflict to be fundamental. Any conflict was sufficient, and something small, such as removing a substation, would be enough to engage the restriction. And the judge did go on to say that this fundamental alteration test, if it existed, and he was proceeding on the basis that it did, because both parties agreed on that, and it was suggested in Finney, and indeed that was based on Arrowcroft. And he said that fundamental alteration test cover cases where there was no conflict with the description of development. And as I said, the judge found that there was a conflict with the operative part by removing the substation, but in an obiter passage, given his conclusion, he went on to say that the removal of the substation was further unlawful because it would be a fundamental variation. It was a central part of the development in the original permission. So it's suffice to say that the position on Section 73 is somewhat a little unclear. Can't amend the description development. That seems clear, I suppose, and it's not restricted to minor material amendments. But what about fundamental alterations where there is no conflict? And Fisk suggests that there is this second restriction, albeit that wasn't a question for the court to decide in the end, and the judge did note that there was some doubt in the case law on that. But Armstrong says the question does not arise. So where are we at the moment? Well, and looking ahead to this year, Fisk is under appeal, so the Court of Appeal will hopefully provide some further guidance on the operation of Section 73. And of course, we do have Section 73B, which has been introduced by the LURA. It's not yet enforced, but that is a new route to make non-substantial changes to planning permissions. And that power could be used to make changes to description of development and to conditions. Of course, the question is, how might that interact with any fundamental alteration test under Section 73? And indeed, what is a non-substantial change to the planning permission? So I rather suspect that the fun has not ended and will not end with LURA 2023, but we'll have to wait and see. And with that, may I hand over to you, Matt, to talk about ASHCHRC.
Well, I very much look forward to the recap next year, talking about all the Section 73B litigation that we'll inevitably be having. So now for something completely different. This is a case about environmental impact assessment, ASHCHRC. Again, many of you will be familiar with this already, and it concerns a challenge by a parish council to the grant of planning permission for a bridge over a railway line to enable housing development in a new garden town that was being planned by the council and the district council, I should say. And planning permission was granted in April 2021 for the bridge, which was to be funded by a grant from the Housing Infrastructure Fund on condition that the council would use best endeavours to deliver at least 826 homes in the proposed new garden town. And since the application itself didn't involve building the road connections to the bridge on either side and was simply for the bridge over the railway line in the middle of a field, it became affectionately titled the Bridge to Nowhere by local residents and the parish council. And as you will know, EIA, Environmental Impact Assessment, assesses the environmental effects of a project. So what is the project in this case? The council argued that the project is limited to the bridge alone, never mind about the proposed plans for the garden town that it would connect to, and the council consequently screened out the scheme as not requiring an environmental impact assessment because, after all, it's just a bridge, so it wouldn't have any significant environmental effects. And the council succeeded at first instance in the High Court. The judge appeared to regard it as conclusive that the application was only for the bridge and not for anything else, and that there had been no intention to salami slice. And the judge considered that because the EIA regulations would in due course apply to the garden town in future, they couldn't apply now. Now, the parish council went off to the Court of Appeal, and their arguments fared better there. The Court of Appeal confirmed that defining the project is not a matter of looking at what is sought in the application. Instead, it's a matter of judgment for the competent authority, subject to challenge on the usual public law grounds. And the Court of Appeal found that the question, is this application part of a larger project, can still be answered yes, even if planning permission has not yet been sought for that larger project, or indeed even if the details of that larger project have not yet been finalized. And the court said that otherwise, a developer could conceal their plans for a far larger development, or ensure that they were deliberately nebulous and bring them forward in a piecemeal fashion with impunity. And what the court held was that any difficulties that arise in assessing the effects of a larger, less well-defined project may affect the environmental impact assessment that can be undertaken, i.e. the amount of detail that it can go into, the amount of certainty it can have. But that's irrelevant to the logically prior question of defining what the project is in the first place. The court said that on the evidence, the sole underlying justification for this bridge was its facilitation of the future garden town, and that hadn't been factored into the council's attempt to define the project. Interestingly, the court didn't go as far as to conclude that the only rational definition of the project was a wider one, despite it being invited to do so. But the court did say that there was powerful support for that conclusion on the evidence, being careful not to usurp the planning judgment of the relevant authority. I think it's one of those cases where there is that tension between saying that something's a matter of planning judgment, but the court having a very clear view as to what it thinks the judgment should be. And see also, for anyone who's interested in particular in this issue, a more recent unsuccessful attempt by the claimant to rely on Ashchurch. And that's the case of Frack Free Balcombe Residents Association against the Secretary of State. Back to you, Rebecca.
Thank you, Matt. So I'm now going to move on to something completely different again, which is the question of enforcement and the case of Caldwell. And this is the most recent consideration of the principle in Murfitt and Secretary of State for the Environment. And that principle, by way of reminder, is that an enforcement notice alleging an unauthorised change of use may require the removal of operational development if that development is integral to or part and parcel of the unauthorised change of use. And that principle can be relied on even if the operational development cannot be enforced against because it has been substantially completed more than 4 years before the enforcement action is taken. And the question in Caldwell was whether that principle applied in circumstances where the operational development was fundamental to the change of use. And Caldwell concerned a site in the Greenbelt where the local planning authority had refused permission for a dwelling on multiple occasions, but a house was nonetheless built and in fact concealed from the local authority following its completion in 2014, and an enforcement notice was finally issued, but not until 2021. And the breach complained of, oh, sorry, my room thinks I've gone, there we go. And the breach complained of was a change of use from agricultural to residential use, and the local planning authority was obviously within the 10-year enforcement period for that, and also the carrying out of operational development, being the construction of the unlawful dwelling, which had occurred more than 4 years previously. So, and the action required by the enforcement notice was the residential use had to cease and the dwelling had to be demolished. And the claimant argued that the dwelling, but not its use, was immune for enforcement action. And the fundamental link between those two is clear if you built a house in the greenbelt, it's difficult to see what else you could use it for apart from as a dwelling. Now, that the High Court reviewed case law on Murfitt, including an important decision by the Court of Appeal called Kestrel Hydro, which is worth reading if you haven't already read it and you're interested in this area. And Mrs. Justice Leven held that there was a limit to the principle in Murfitt where the development was the source of or fundamental to the change in use. And she concluded that the construction of the dwelling in Caldwell, because it was fundamental to the change in use, could not be enforced against. So in other words, the local planning authority got what it wanted in terms of the use of the dwelling ceasing, but it did not get what it wanted in terms of demolition of the dwelling. And there's been a lot of discussion of this decision, which has been appealed, and the appeal in the Court of Appeal is due to be held in March this year. Now, it's worth recalling, of course, that the 1990 Act does set out different regimes for enforcing against a change of use and for operational development. And on the one hand, if the Murfitt principle were to apply in all cases, the 4-year enforcement period for change of use would have a much more limited application, arguably, than that envisaged by the statute. And in essence, if that development were fundamental to a change of use, then the operational development could be enforced against for 10 years. And you might say, well, that's not what the statute intended. But it is an interesting question, because from a policy perspective, some might say, what would be the purpose of enforcing against a use if you couldn't get rid of operational development? And that seems particularly to be the case in Caldwell, where the breach is the construction of a structure in the Greenbelt. But let's see what the Court of Appeal says once this has been heard in March. I've also put on this slide see also Devine. Now, I say see also because it's also an enforcement case, but it's really on a very different point to Caldwell. It concerned the approach in Sage and Secretary of State for the Environment. No relation. In fact, none of the Sage planning cases are of anything to do with me, I should say. But it's the relevance of the intentions of the developer or landowner when assessing the character and purpose of the structure against which the local planning authority had taken enforcement action. So that one's worth a read if you're into enforcement stuff more generally. Over to you again, Matt.
Thanks, Rebecca. Now, the next case is C.G. Fry and the Secretary of State. This will be familiar to many of you. I don't know, Rebecca, whether you could just flick on the slide to the next one. This is the case where the High Court upheld the lawfulness of a decision by the authority to refuse to discharge planning conditions that were attached to the grant of reserved matters approval due to the absence of an appropriate assessment to guarantee no adverse effect on the integrity of protected habitat sites from additional nutrient loading, the so-called nutrient neutrality issue that has been dominating headlines in the planning world over the past year or so. And it's important to recognize that these conditions that were at issue had nothing to do with mitigating ecological impacts. And there were no other concerns at all about the acceptability of the details that were being submitted to discharge those conditions. And the starting point is what the legislation says. If there are likely significant effects from a project on a protected site, that the habitats regulations require an appropriate assessment before any consent or permission or other authorization is given for the project. And now, as we know, in a multi-stage consent situation, like an outline planning permission, there is no ability to implement the consent until reserved matters approval has been given. And therefore, the requirement for an appropriate assessment, if one has not been done already at the outline stage, should apply at the reserved matters stage, according to the High Court. And that was based on previous authority that the court referred to. The judge also accepted the Secretary of State's submission that the same should apply to the discharge of pre-commencement conditions, so not reserved matters approval, but pre-commencement conditions in circumstances where commencing development in breach of those conditions would result in the development not being authorized by the permission. And in doing so, interestingly, the court left open the question of whether the same principle would apply to pre-commencement conditions which don't go to the heart of the permission, applying the Hart aggregates line of authorities and the Whitley exceptions. The court also didn't consider whether it would apply equally to conditions which prohibit above slab level development, i.e. you can do anything that's below that or any demolition works and so on, but you can't do any development beyond then. We don't know whether Fry would apply equally to those, or indeed whether it would apply to a condition which enabled the construction of a project, but for example, some housing, but not the occupation of those houses. And that's obviously a situation where, particularly in this context, what's actually having the ecological impact on the protected site is the occupation as opposed to the construction, because it's the use of the houses rather than the construction of them itself that is resulting in the additional nutrient loading. So I think there's an interesting open question at the moment as to how Fry would apply in that particular context, looking at occupation conditions. I won't say an awful lot more about Fry because the High Court granted permission for the developer to leapfrog over the Court of Appeal and appeal straight to the Supreme Court. The Supreme Court then, in an unusual move, rejected this and said it should go to the Court of Appeal, and the Court of Appeal has listed Fry, the appeal in Fry, to be heard in March this year. So there will be a more definitive answer from the Court of Appeal, hopefully, on this issue in due course. And it'd be interesting to see whether they look into this issue of how it might apply to different types of condition rather than just pre-commencement conditions and reserved matters conditions. Okay, back to you, Rebecca.
So the next case I'm going to talk about concerns the tension between the substantial level of growth arising from new developments and stretched NHS trusts. And this is a tension which has played out for several years in planning inquiries. And the Leicester case was the first case where the issue came before the High Court. Now, ordinarily, the impact of a particular development on local services is managed by SIL/Section 106. The test for imposing a planning obligation is, of course, found in Regulation 122 of the SIL regulations, which requires, among other things, that the contribution is necessary to make the development acceptable in planning terms. But what about national services, such as the police, or in this case, the NHS? And really the big question is who should bear the financial consequences of additional people in a particular area. In the case of the NHS, central funds do cover an element of population growth, but the trust in Leicester, and many others have argued, as I've said before, planning inquiries, is that there is a funding gap in the first year of occupation of a particular development where, broadly speaking, central funding has not yet been adjusted to take into account the growth of population in a particular area. Now, in Leicester, the permission was for a mixed-use development, and it included up to 2,750 homes. It was a very large development. In fact, it was the single largest allocation in the local plan, and it was responsible for delivering a third of houses in the local authority's area. And the NHS Trust originally sought a contribution of about 1.4 million, and that came down to about £900,000. And the Trust said that that was necessary to bridge this alleged funding gap for the first year of occupation. Now, in negotiations, the LPA did ask why the gap couldn't be accommodated by central funding, and in particular the local planning authority struggled to understand how the central funding couldn't take into account an element of growth in population, or indeed how the NHS Trust couldn't simply negotiate a new arrangement in the time lag between permission being granted and the occupation of any dwelling on the site, which, given the scale of permission in this case, one would imagine would be a fairly substantial lag. So The local planning authority concluded that the trust, in effect, failed to explain these points, and so it decided that the SIL tests weren't met and granted planning permission without a contribution towards NHS services. Now, before the High Court, the trust argued that the local authority had erred by not requiring the developer to make a contribution to its services. And in relation to the SIL tests in particular, it argued that it was legally irrelevant for the local planning authority to take into account the trust funding arrangements, because those arrangements, it said, did not relate to the development or use of land or the use of the site. And it made a broader point that if the availability of alternative funding arrangements were to be material, then anybody with alternative funding routes would be unable to obtain a Section 106 contribution. And in relation to the funding arrangements more generally, the Trust said that this funding gap arose as a necessary consequence of its funding arrangements, which couldn't have regard to the consequences of future planned growth in population. And in any event, it was impermissible for the local planning authority to question the basis of those funding arrangements. However, and this is perhaps why the decision is slightly unsatisfactory, the Trust did make some important concessions in the hearing. First, it accepted that if it couldn't show a funding gap for the provision of health services, which was attributable to the occupation of housing on the site, there would be no relevant impacts to justify a Section 106 contribution. So in other words, the funding gap was essential. And if the Trust couldn't demonstrate it on the facts, then no contribution. And second concession was that there was, in fact, the Trust admitted, nothing to preclude the negotiation of a contract which could have regard to population growth in the first year of occupancy. Mr. Justice Holgate was, I think it's probably fair to say, fairly unimpressed by those concessions. And he held that the Trust's acceptance of the need to show a funding gap in reality meant its arguments on the relevance of its funding arrangements simply fell away. But he did go on to give his views on that point. And he said that in any event, it must be relevant to look at the Trust funding arrangements because they were entirely integral to the issue that was before the local planning authority. It was, he said, in the very nature of the harm claimed by the Trust that makes the alleged funding gap an integral part of its case. And he said that that conclusion was reinforced by the position after that crucial first year. The judge noted that a developer could not in any way be required to pay for those costs because the developer would be in effect paying for a community benefit, which, in other words, increasing the funding of the NHS, which had no proper planning purpose or relationship to the development. And Mr. Justice Holgate said, well, that analysis can't be any different for residents in the first year. So the local planning authority was entitled to and had properly considered the issue of the Trust funding and had reached an entirely reasonable conclusion. And that was sufficient to dispose of the Trust's claim, as I say, largely based on a concession made in the hearing. However, Mr. Justice Holgate did go on to consider the wider issues behind the Trust's argument. And he made two important points. First, he said that the Trust justifications had to be viewed in the context of the statutory framework for secondary healthcare services. He said that, well, as a matter of logic, the contribution related to people who were new to the area, but those people were entitled to NHS services wherever they lived in the country. And the obligation to provide those services lay with the NHS. And that was in contrast to services secured by a typical Section 106 obligation. For example, a highways authority isn't under a statutory obligation to fund improvements to the highways network in the same way as the NHS is under a statutory obligation to provide secondary healthcare services. Second, Mr. Justice Holgate went even further, and he said that if the local planning authority had agreed to the Trust request for a contribution without being adequately satisfied there was a funding gap, it would have been open to criticism such that its behaviour could be characterised as unreasonable in the context of a planning appeal, and therefore open it up to liability for costs. So some fairly stark views on that funding gap issue. Now, of course, Mr. Justice Holgate was not deciding the bigger principle in this case, which is whether the contribution of the kind sought by the Trust could ever be lawful. And there wasn't enough information about the gap and the size of the contribution needed in the case to reach decision. However, he did leave open the possibility of considering the position if there was enough information provided in a future case. But he did say that if it were the case that generally that first year funding gap could be addressed through negotiations for central funding, then it would be difficult to see how another trust could show how the necessary test in the SIL regulations could be met. And Mr. Justice Holgate also indicated that even if a funding gap could be shown, the local planning authority might raise the possibility that it's a systemic problem with the way that national funding is distributed for the NHS, rather than being directly related to the development. So there were pointers that while a future case might consider this, prospects might be a little bit low for an NHS trust, at least relying on the kinds of arguments that were made in the Leicester case. I've put at the bottom of this slide, there was a further case, however, a few months later in Worcestershire, where the trust had sought a contribution of about £3 million, which was later revised to 1.8 million. And that request was refused by the local authority in question, and the trust brought an application for judicial review. And in the permission hearing, Mr. Justice Holgate again looked at the information provided by the authority. He said, well, the position is that you have to show a funding gap, and again, you have failed to provide enough information to satisfy the local planning authority of a funding gap, so he therefore refused permission. So I rather suspect watch this space, and certainly it may well be that other services such as the police find a way to make different arguments in a similar context. It'll be interesting to see what happens this year. Back to you, Matt.
Thanks, Rebecca. We've got another Fisk case. It is the same, Mrs. Fisk. Another claim for judicial review brought by her. And this time it's challenging the grant of planning permission for the distribution network operator substation that Rebecca was talking about a few cases ago, to connect a proposed solar park to the national grid. So in terms of what Rebecca was talking about, you had the 2017 permission for the solar park. You then had the 2021 permission for the substation, and that's the one that's being challenged in these proceedings, not the later Section 73 permission that Rebecca was talking about. And the question for the court was whether the local authority had erred by failing to have regard to an obviously material consideration, which is the relevant test for what considerations have to legally be taken into account, but by failing to take into account the incompatibility of the 2021 permission for the substation with the earlier grant of planning permission for the solar park itself in 2017. So as I said, this is the same incompatibility which resulted in the subsequent Section 73 application being made, which Rebecca was talking about. Now, as you'll know, the issue of incompatible planning permissions was the subject of probably the biggest planning case of 2022, namely the Supreme Court's judgment in Hillside. There was no dispute in this case, the Fisk case, that there were certain differences between the two planning permissions, which meant that they could not be implemented consistently with each other. And Mrs. Fisk sought to argue that this incompatibility was an obviously material consideration, i.e., it had to, by law, be taken into account. In that the local authority should be thinking about whether it wants to grant planning permission for something which is incompatible with a previous grant for interconnected development. And the Court of Appeal, in a judgment that was handed down just before Christmas this last year, upheld the High Court's judgment, disagreeing with Mrs. Fisk. The court noted that the planning system does not preclude multiple planning permissions being granted for different developments on the same site that are mutually incompatible, and the future actions of the developer to deal with the incompatibility, such as, for example, by a Section 73, see Rebecca's case, was not a matter on which the council needed to speculate or anticipate. That was a matter for the developer alone, and was not the authority's job, to use the words of Keith Lindblom. It did not bear on the planning merits of the proposal, as the judge said. So that was the answer given there. Rebecca, back to you, I think, for the last main case that we're going to be talking about. Then there'll be a few things to sweep up at the end.
Thank you. Yes, so we're going to end with an important procedural reminder. It's a brief point, but it's very important. It concerns the time limits for bring an application for leave for a Section 288 challenge. As we hopefully all know, under Section 288(4)(a), that application must be made before the period of 6 weeks beginning the day after the date on which the grounds to make the claim first arose, i.e. the date of the decision. Now, there's practice direction 54D, which says that the claim form must be served within the time limited by the relevant enactment. So in other words, it must be served within the 6-week period. And you can probably all guess what happened in Telford. That was a challenge to a decision dated the 27th of March. I've done the maths for you. That means the 6 weeks expired on the 8th of May, which, as we might all recall, was the coronation bank holiday. So, in fact, the 9th of May. However, unfortunately, the applicant left things a little close to the wire, and the application was filed with the court on Friday, the 4th of May, so just before the coronation bank holiday. Sorry, I think Thursday. And it wasn't issued until the 15th of May. And then with some issues with having the wrong address for service, it was finally served on the 18th of May. Secretary of State looked at his calendar and applied on the 9th of June for a declaration the court had no jurisdiction because the claim form had been served out of time. The would-be claimant in that case, in fact, only applied for an extension of time after, in the order listing the matter for a hearing, the judge there set directions which suggested the claimant, if so advised, make an application for an extension of time. And when the matter came to a hearing, I think it's fair to say the judge was not impressed. The applicant argued that it wasn't, in effect, their problem that the court did not issue the claim until after the deadline, and tried to say that it was sufficient to send the application into court within the 6-week period. And the judge said that went contrary to the very clear wording of the practice direction, which requires service within that 6-week period. So in essence, the judge said, well, that might seem unfair, but that 6-week period is very important in statutory review claims. It was open to a claimant to flag the urgency with the court when the claim was filed and chase for issue. And a claimant who did that would have good prospects of obtaining an extension of time if the claim were in fact served out of time. However, the claimant in that case didn't do that. So unfortunately, they were also refused an extension of time. And it really provides an important reminder not only to get your claim in early, but if for whatever reason it is a little bit late, to do everything that you can to chase the court to issue the claim as soon as possible and then make a very prompt application for an extension of time. I put Hulton at the bottom of the slide there, and in that case, the court considered the principles relevant to the grant of an extension of time / relief from sanctions in the context of a statutory review claim, and it confirmed that they will be the same for judicial review based on a good law project case. So if you do find yourself asking for an extension of time, that is a good case to have a look at. Right, Matt.
Thanks, Rebecca. We're it's 10:45, so I'll let things run on a little bit longer just so that we can wrap things up. But obviously, anyone who needs to go should feel free to go. This is just a slide to say that there were 3 Supreme Court cases last year, all of which are, I would say, planning related. Certainly the first one is directly planning related. It deals with the materiality of a statutory trust requiring land to be public open space in the context of an application for planning permission to develop that land. The Curzon Park case is all about compensation for compulsory acquisition of land to facilitate the construction of HS2, and the question is whether, in determining what development might have been possible on 4 contiguous sites in Birmingham to be valued for compensation, it's material to look at the cumulative position of all the sites together, or to assess each piece of land in isolation. And then lastly, Wolverhampton is about the court's power to grant so-called newcomer injunctions against trespassers. So that's injunctions that will apply to persons unknown who were not identifiable or on the site at the time when the injunction was granted. So that they are the 3 Supreme Court cases And then we've got two further slides that are just other cases to note for you to go away in your own time if you do want, if you're interested in any of these issues. The first set are on AONB national policy. The second case is a bit of a cheat because it's not actually a case from 2023, but for all of those who are interested, especially since we've been talking about some of these issues, there was a very recent judgment from I think last week or maybe earlier, even this week, of Dennis, that's to do with Hillside and Section 96A and severability of planning permissions. There's been a whole load of cases about asylum accommodation, both in terms of RAF sites and also barges and so on. That's all set out for you there. And then decision making. We've got decision making cases to do with both appeal decisions by inspectors and also local authority level. And then Rebecca, you're going to do the second slide, I think.
Yeah, thank you, Matt. So yeah, on this side, it's just a continuation. Oh gosh, sorry, giving it away. It's just a continuation of other cases to note from 2023. I've gone too far back. There we go. So we have some cases on carbon emissions and airports, and those cases engage quite interesting questions about the extent to which aviation emissions should be relevant considerations in decision making in relation to this kind of development, and also the extent to which general policies could be relied upon where there's a specific development with climate change impacts. Heritage harm, the East Quayside case has some very useful guidance on the approach to take to assess the level of harm that a development might cause, the significance of a listed building. DCO challenges, we've lumped all these together, but they do all raise quite different points. If you're concerned about a DCO being made before a permanent supply of water has been identified, the Sizewell C case is for you. And the Suffolk case raises an interesting procedural point about agreements with landowners, which provided not to, in effect, oppose the DCO applications. And then Durham, which was about the threshold within for a development being treated as an NSIP. And then GPDO, the cab housing one, is a useful reminder of the factors which a local planning authority could take into account when considering whether to grant prior approval. So now, cases to watch.
Cases to watch in 2024. We've included just a few here. I'm sure there are many others that we're just not aware of. But the long-awaited Supreme Court judgment in Finch is anticipated later this year. That was heard in June 2023. So the judges have been spending some time now thinking carefully about how they want to answer the difficult question in that about environmental impact assessment and end-use carbon emissions. Marks and Spencer, that the refusal of planning permission by the Secretary of State to Marks and Spencer has generated a challenge by M&S that is going to be heard by the High Court for 2 days in next month. I'm acting for Save Britain's Heritage as an interested party in those proceedings. CG Fry, as I said, the appeal is going to be heard in March 2024. Same goes for Caldwell. And there are some other cases coming through the pipeline in relation to Home Office asylum accommodation, Clark Holland in the Court of Appeal, and the second Parks claim, the second Bibby Stockholm claim as well. So in view of the time, we're not going to be able to answer any of the questions in particular detail. There's been some brilliant questions asked. I think just to pick a couple that I've been looking at whilst Rebecca's been talking, there's a question about the FISC situation where essentially couldn't the applicant just not implement the part that he originally got planning permission for and simply, i.e., not build the substation? And I think that the answer to that lies in the later case that we were talking about to do with FISC, which is that you had a situation where there were two planning permissions that were incompatible with one another. So if you decided to build your substation, in the place that was authorized by the later permission, that would render the original permission unimplementable. So, i.e., it couldn't be completed in accordance with the plan. So you would get a hillside issue that would arise as a result of that. But it's a very good question. There's also a question from someone about we need some guidance on what is and isn't minor in the context of Section 96A and 73B. And I would agree, subject to the caveat, of course, that the courts tend to be quite reluctant to um, give too much guidance on a word like minor, because it's thought best to leave it simply to the judgment of the authority in any given instance. And just picking up one other question that's been asked, I mean, there's a bunch of other ones, and do please contact us if you want to engage further in these. There's a condition that says do not commence development apart from demolition until some detail is approved. Is that a proper condition precedent that can render the development out of time to be begun? My answer to that would be it's not a genuine pre-commencement condition because it doesn't preclude development from taking place on site, which includes demolition. Rebecca, did you have any that you wanted to just briefly deal with, and then we'll wrap things up?
Yeah, thanks, Matt. As you say, some very interesting points being raised in the questions, and I'm sorry that we don't have time to consider more of them in more detail. Someone's raised an interesting point about LPA preferences for granting a very detailed description and development as opposed to a broader description, which obviously narrows the scope for the applicant subsequently relying on Section 73. I mean, in one sense, I suppose the LPAs are therefore meaning that they don't get flooded with Section 73 applications because they have a very specific description and development. Although obviously there's the Section 96A and of course the changes to LURA. So it's difficult to say that which approach is better, of course, but LPAs are certainly, in terms of making development work in their area, they're probably not doing themselves much favour by limiting the flexibility of the permission in that way.
Good. Well, thanks so much, Rebecca, and thanks to everyone for joining us this morning for this recap of 2023 case law in the planning world. And I hope you all have a fabulous rest of the week, and hope to see you again on other landmark webinars soon. Thanks very much and goodbye.
Thank you.